Good afternoon, everyone. This meeting is being recorded, and your continued participation is your consent to being recorded. Welcome to the Broadband Office's Labor Law Compliance webinar. There is going to be time at the end of the presentation for questions and answer. Any questions that you have, please feel free to put them in chat throughout the presentation, and we will be pulling the questions from there at the end for questions and answers. I will turn things over to Brandon Carson, the Executive Director of the Broadband Office. Brandon?
Thanks, Mel. I appreciate the introduction. Good afternoon, everyone, and thank you for joining us today. So the Broadband Authority is collaborating with our colleagues at the Department of Labor and Industry to share information on Pennsylvania's prevailing wage law as it relates to our inaugural grant program, the Broadband Infrastructure Program, or BIP. The program provides $200 million in available funds from the U.S. Treasury for broadband expansion efforts here in Pennsylvania. As some of you are probably aware, we began accepting applications for the program on May 10th and recently announced a 30-day extension to the submission deadline. So applications will now be accepted through August 9th. That information was announced on Friday of last week. To assist entities with the development of the proposals, we've created a web map that can be found on the DCED website, along with an updated list of frequently asked questions and a program webinar that provides information on the guidelines and the portal that is needed to submit an application. I'll ask Mel to drop the web link in the chat for everyone so you have those that link. So today's webinar will focus specifically on Pennsylvania's prevailing wage law and how it impacts this program. If you have other program-related questions, we ask that you contact the authority by emailing the resource account, which will also drop in the chat so you have that email for our resource account. I want to point out that Pennsylvania prevailing wage requirements as they relate to this program and upcoming broadband grants are not determined by the Broadband Authority or by DCED. These are administered by PA Department of Labor and Industry and reflect Commonwealth-wide requirements. I hope you find the information provided here today helpful as you continue developing your grant proposals. We're excited to partner with you all to expand reliable, high-speed internet across the Commonwealth. And we're looking forward to reviewing the grant materials that we know you're working very hard to develop. So thank you for that. Thanks for your efforts. So now I want to turn things over to my colleague, Brian Smolik. Brian is the Director of Labor Law at the Pennsylvania Department of Labor and Industry. He's going to walk us through a few slides, and then we're going to have some time for a question and answer here at the end. So Brian, I'll hand it over to you.
Thank you, Brandon. I appreciate it, and I'm really honored to be here. Thank you, everyone, for attending, and we also hope that this noble venture in Pennsylvania will be assisted today with our information that we would like to share about prevailing wage. It's a very important program, and we're hopeful that we can provide information for everyone to get a good understanding of the responsibilities of under the Prevailing Wage Act and some other laws as well. And if someone could just come off mute to confirm that you do indeed see my PowerPoint before I begin, I would appreciate that.
Yes, sir, we can see your PowerPoint.
Thank you very much. So as mentioned by Brandon, my name is Brian Smolik. I am the Director of the Bureau of Labor Law Compliance. We have an agenda today for you. I wanted to just do a brief introduction of us, an overview about some of the things that matter to this Bureau, some other laws that I want to very briefly discuss because I feel that they're important. Then we're going to get into the meat and potatoes of why we're here, which is prevailing wage, and hopefully, yes, have time for questions and answers. I will make my contact information available at the end of this slideshow for anyone who would like to discuss anything in more detail or even questions in an email to us. That would be perfectly fine as well. Anything that we can do to assist. So labor law compliance enforces 13 different labor laws. We are tasked with investigations and enforcement of things such as child labor, minimum wage, wage payment, other laws not necessarily related to construction, involving medical issues with the Act 102 law involving hospitals, right? So we have a lot of different laws that many times will sort of merge together. On construction projects, we might find issues of people not being paid proper overtime, wages not possibly being paid correctly, maybe child labor issues. So we execute our authority by doing these investigations, but also doing outreach like today. It's very good to prevent violations and provide knowledge to anyone involved with these different types of programs or different industry sectors, so we could try to not allow violations to happen. It will make our lives much easier. We cover these laws on your screen now, and I wanted to have some close attention paid to a few before we get to the prevailing wage law. These are important for everyone out there to know. Many of you attending this conference today might be your first time in Pennsylvania doing work. I'm not sure what the background of all of the different participants will be, but in Pennsylvania, we have a wage payment and collection law, which states in essence that you must be paid for the time that you work on a set pay date as established by an employer. The cases that we get oftentimes involve workers being paid late paychecks, not being paid at all. So please, if working in Pennsylvania, pay close attention to the wage payment and collection law. Also, the Minimum Wage Act. Now, today we're talking about a minimum prevailing wage, which is a little bit different from minimum wage, but it's important to note. The reason I bring this law up is because the provisions in Pennsylvania for overtime, anything worked over 40 hours being time and a half, that's found in the Minimum Wage Act. That applies to Pennsylvania prevailing wage jobs as well. Hourly workers must be paid time and a half for any hours worked over 40 hours in a 1 week period of time. So when we talk about a prevailing wage becomes the regular rate of pay, and that's how overtime must be calculated. Again, I know we're not here today about overtime, but it's worth noting that if you have questions about overtime, you're not going to find it in the prevailing wage law, you'll find it in the minimum wage law. And finally, and I really wanted to emphasize this before we get to the Prevailing Wage Act itself, the Child Labor Act. Please pay close attention to the rules and regulations concerning child labor. We have seen a unfortunate dramatic uptick in violations that we're finding many times on construction sites. So please make sure that if you're working in Pennsylvania, you're very cautious about the ages of the people that you employ and what type of work you have those people do. We have a listing on our website of prohibited occupation that minors may never do. It's broken down by age, under 18, under 16. Many times construction in general should not be done by minors. So please, this link, which is on this slide, is clickable. If I click it now, it will not open to the screen for you to view it, but trust me, it's there and it will be provided for everyone on this call, I believe. So any links that you see highlighted in blue through this presentation, you'll be able to click on those and open them up to where they are found on our website as we talk about them. Other laws of note, Act 72. What Act 72 establishes is that you must, if you pay someone as an independent contractor, they must be an independent contractor. If you misclassify a worker as a contractor, but they are really an employee, that could be a violation of Act 72. The Medical Fee Act, if you have your workers take a medical exam of some form and it's required by you, you must pay for them. Act 75 or E-Verify, established in 2020, you must do an E-Verification for anyone that you hire on or after that date. Apprenticeship and training. There's an official apprenticeship and training office within our department that helps establish programs for you to train workers. To be considered an apprentice in Pennsylvania on a prevailing wage job, you must be registered with that Office of Apprenticeship. And finally, the personnel file inspection law. Seems like it's, why are we talking about that? Well, quite frankly, because if an employee requests to see a personnel file, you must show that to the employee. So thank you for allowing me to digress before we get into the meat and potatoes, but these other laws too have a direct impact over this program. But we're here about the prevailing wage law. So let's unpack. The Department of Labor and Industry, through our Bureau of Labor Law Compliance, which is the agency that I'm from, we determine prevailing wage for the construction industry. We enforce those rates in the classifications that we set forth. When we give prevailing wage determinations, we have several categories that we can apply to a job. So for example, we could apply a building category to a job. We can designate a project to be heavy construction, highway construction. Quick rule of thumb on this, if you're in a building, if there's any work taking place in an actual structure of some form, it's probably a building job. Any outside work involving, let's say telephone poles or any wiring or cabling outside, that designation will be a highway construction project. There are times when there's projects that are both involving highway work where you're connecting a structure to a network and then work inside that building itself to establish a connection to whatever you have outside. Those designations would most likely be a building/highway job in which when you get your rates back from us, it will be broken down. You might have to look to two different sections depending on the work and the phase of work that's being done. The prevailing wage regulations allow the Secretary of Labor and Industry to consider collective bargaining agreements for the purposes of determining prevailing wage rates. And that's determined by locality. We're going to get into that in a few slides. As mentioned before, these workers on your site, after rates are obtained, hourly workers on site would be entitled to overtime. They're entitled to get the prevailing wage for the work that they're doing. There might be times even managers, supervisors, or professionals have to receive that overtime if they're hourly workers. All these rules, as mentioned before, kind of merge together, right? And then finally, all of the rates that we give out from our department are all out there on an easily usable, searchable website. The link on that slide would take you directly to that search page. But in a few slides, we're going to give an example of the way rates will look after you get them back from us. So the search page, however, is very simple to use, extremely simple. We'll get into that. So what exactly is a public works project? We think about construction, we think about the work that all of you folks out there most likely do, and we probably don't think prevailing wage, right? But we have to today. And the reason why is because we're using public funds. That's the most important thing. And that's why we set the rules on jobs of this nature, right? We have a different playbook for prevailing wage as opposed to anything else that's not funded by state dollars in some form. This is the four-prong test. Certain work, which is construction, reconstruction, alteration, demolition, and repair, if it's done under contract, using funds of a public body or grant money, and is on a project that is estimated to be more than $25,000 in cost, those four things combined together would make a job be prevailing wage. If it's not done under contract, no public funds, and if the project is only $20,000, it's not prevailing wage. But when all four prongs of this test are met, rates must be applied for, and our department would have to enforce prevailing wage on a project of that nature. But let's go into some details on what these four prongs actually are. Certain work: construction, reconstruction, alteration, demolition, repair, other than maintenance. There's a very narrow maintenance exception. I don't believe, and this is my assumption, I don't believe the work that we're talking about today would involve maintenance. However, I have been told by some folks from DCED that there might be some maintaining of poles by replacing them. That is not maintenance because we're talking about reconstruction, alteration, or major repair work. So as you encounter different things out there in Pennsylvania, perhaps there will be some damaged poles, maybe things that don't work anymore, and you replace that with brand new equipment, brand new items. It's not really maintenance anymore because maintenance is if we're not repairing, maintenance is only if we're repairing the existing facilities by not changing the type, extent, or facility itself. This is established by Commonwealth Court and Supreme Court decisions. And again, it's narrowly construed. Let's talk about prong number 2, done under contract. So it's important to note that the contract does not have to be with a public body. That was established as well through a court case. When we talk about done under contract, if an entity receives a grant and the entity who receives the grant will have their own employees do something, there may not be prevailing wage. Of course, each circumstance would be very detail oriented, but it may not be. However, if there's work that's contracted out because let's say the entity that received this grant can't do a certain part of that work. Now we have a contract, so now the work being done under contract must be prevailing wage. There could be a possibility in which a project has a delineation in which there's a logical demarcation from one part of the job to another part of the job. Let's say different phases, different parts of work being done. Those are very case specific, And here again today, I do not believe we're talking about anything of that nature. But if anyone has questions about it, we can entertain those questions. Use of public funds. So again, when we talk about the prevailing wage world that you're entering in, we think about awarding agencies. We think about school districts, government agencies, people who do this work and put things out. Let's say a new roof on a school must be installed. Perhaps new networking in a school, maybe new camera installation in a public building. Those make sense. But now we have something where there's grant money. So private entities which are using grant money, such as DCED funded projects, Office of Budget, RACP funded projects, that grant infusion, that public tax dollar into a private job creates the need for prevailing wage to be done. So yes, we have all these awarding agencies, but now because of grant funding being infused into private work, now we have use of public funds on a private construction job. Prong number 3 is met. And then finally, the estimated cost for the entire project is more than $25,000. This is prong number 4. Must be a good faith estimate. So if something comes in $24,990, okay, we have to ask some more questions about that. Good faith estimate is what's important. A contract cannot be split up into multiple jobs just to avoid prevailing wage. By the way, that $25,000, where do we come up with this? It's in the law. It's based off of the cost of the materials and labor combined together. Now let me explain. If we have a project that's, say $5 million, but you only have $20,000 of grant money in that project, some might say, well, it's only a $20,000 job. It's not a $5 million job. That's incorrect. If there is the infusion of grant money into a project and the total cost of the materials and labor is more than $25,000, it's publicly funded in some form, it's prevailing wage. The law doesn't say more than $25,000 in grant money. It says more than $25,000 in estimated cost with grant money in there. So that takes care of our 4-prong test. Moving on, separating public funds from private funds. Here again, I'm going to mention this in passing. I don't necessarily know if your projects will have this type of issue, but it's where there's a strong and logical demarcation between phases. Perhaps one phase is privately funded, another phase is publicly funded. The question we often get is, well, is this entire project covered by prevailing wage or only certain parts? Case by case question on that one. You would have to send us the request and give us all the details in which we would make a determination and send that answer back to you. This, by the way, is again established by court. There are different rules and regulations in play, but as the decades have rolled on since the 1960s when prevailing wage was first enacted, we've had major court decisions that have shaped the way as to how we enforce prevailing wage. Again, we cannot allow any artificial construction phasing that has no independent business justification. So when these phases are looked at, it's case by case, but coming up with phases to purposely avoid prevailing wage, that would be a no. So what's not covered? We're talking about what's covered. Let's talk about what's not first. Legitimate maintenance projects. Things, again, back to what we said before, where the size, the shape, the overall, the structure itself is not being changed in any way or repaired in any way. I often use the example of carpet. I know we're not here for carpeting today, but I'll use it anyway. If you have a brand new carpet project in your building, replacement of everything, that will be prevailing wage. But a little patch got ripped, or a little tear in there, we have to fix that tear. That will be maintenance, right? Think of it that way. Replacement, making something different, changing something. So for you out in the world you're in, that pole replacement, right? You might be replacing it with a very similar looking pole, but it's different, it's upgraded, it's not maintenance. Also not covered, projects that specifically have language making them subject to federal Davis-Bacon and the Walsh-Healy Acts. It's my understanding with this particular program, there was no language making these dollars subject to Davis-Bacon. Therefore, we're talking about a state prevailing wage because we have a pass through DCED and grants being administered through DCED. So the fact that there's no language specifically making these be Davis-Bacon is why I'm here today as opposed to someone from the U.S. Department of Labor. Okay, types of workers who are covered by prevailing wage. Laborers, mechanics, skilled and semi-skilled laborers, apprentices employed by a contractor or subcontractor, on that public works project, regardless of whether their work becomes a component part thereof. What does that mean? Good example. You're going to be doing outside highway work. You're going to have someone who's a flagger on a highway. That component of that work becomes subject to prevailing wage. There's actually a laborer rate for a flagger, and each rate would be different depending on the county you're in. So each type of work, each component of this prevailing wage project has coverage now that we established the four-prong test. So typically, who's not covered? Well, let's first talk about who's covered. Workers performing any testing and balancing of any air handling systems, any electrical devices. Surveyors are covered if it's in part of the construction project, and truck drivers are covered as well. We're going to have a slide on that briefly in a few seconds to kind of educate when a truck driver is definitely covered and when there may not be coverage. Workers not covered by the Act. Material handlers dropping off supplies to the job site and not staying and not doing any work. Not covered. Architects, engineers, people who are performing any geotechnical and inspection services not covered. Workers performing off-site work, not covered. And finally, non-working supervisors. When we talk about this idea of a non-working supervisor, let's pay close attention to what that means. If you have a foreman on a job who's not doing any work itself on that project, but only directing, that person's not covered by prevailing wage. However, when they perform any work, when they actually pick up a tool of some form, run a machine, erect a line, put in conduit, things of that nature, they are covered. So a non-working supervisor who's not doing any work at all, don't worry about that person. But there is coverage with that person is performing work itself. So that's very important to note. Mute my distraction if I can. Sorry about that. I thought I said I was unavailable, but apparently I didn't click the right button. Apprentices on a job site. Mentioning before an apprenticeship situation. An apprentice on a job site is someone who's registered with the Pennsylvania Apprenticeship and Training Office. We oftentimes encounter folks who are not registered in Pennsylvania as an actual apprentice. There's no program in Pennsylvania that allows for that person to be paid less than the prevailing wage. It's important to not pay them the incorrect rate. I truly apologize for my distraction. I don't know if you all can hear that, but you're gonna have to bear with it for a moment until I can fix that.
Brian, we actually can't hear anything, so you're
Oh,
good.
perfect. So only I'm distracted, but no one else is. Beautiful.
Only you.
It's all
sir,
good.
yeah.
It's all right. All right, let's talk about custom and usage. Before I move on, let's go back to apprenticeship and training. There's a ratio that has to be kept when there's any apprentices on a job site. There's program standards that must be adhered to. And again, if we encounter a situation where someone is being paid as an apprentice, typically an apprentice is someone who's getting on the job training and classroom education. It's registered through the state of Pennsylvania Office of Apprenticeship and Training. And those folks need to get paid the correct percentage of the journey worker rate that they would be at. Custom and usage. How do we determine custom and usage, and what is custom and usage? So prevailing wages are determined by submissions to our department on localized data and rates that are paid based off a localized custom and usage. It's basically the rate that most commonly prevails in geographic locations. So remember this, if someone calls me up and says, Brian, what's the prevailing wage rate for a laborer in Pennsylvania, electrician in Pennsylvania, plumber in Pennsylvania? It's going to be different based off of the locality where the work is taking place. Rates are often different, not only by county, but some counties have different rates based off of where in that county work is. I name on here the ironwork, the steam fitters, the electricians. Oftentimes their rates are sometimes divergent based off of rivers and roads that disconnect certain localities. What does locality mean? We're blessed by the law. It actually defines it for us. I'll read it. A locality means any political subdivision or combination of the same within the county in which public work is to be performed. When no workmen for which prevailing minimum wage is determined hereunder are employed by the locality, locality may be extended to include adjoining political subdivisions where workmen are employed in those crafts. What does all this mean? It means what again, what prevails as the custom and usage in certain localities. That's why we have different rates based off counties that we are, all 67 counties in PA and localities within it. Notes. So on our website, we provide on our quick links page a listing to all the different notes that have been established in history of our Pennsylvania Prevailing Wage Act. These notes have existed for decades in some instances and half a decade or so in other instances. We divide these notes up into different sections. This is where some people get a little bit confused. So we have a 29 county note, a 33 county note, a 5 county note. We even have a 22 county note for operators. What do these mean? By the way, here's a listing of all the links you can find on our website. Here again, this PowerPoint slideshow will make each link clickable that you can open each one of these. This 29 county note, 33 county note, think of it this way. We have the Susquehanna River, 29 county to the east, 33 county to the west. The 5 county note is normally Philadelphia and the 4 counties surrounding it, right? When you click on each one of these links, you actually see the counties listed out. So if you have a prevailing wage law in, let's say, Erie County, you would be looking to the 33 county notes. If you have a job in Philadelphia County, you look to the 5 county notes. Tioga County to the 29 county notes. Here again on our website, it's all listed. The counties are on each one of these links. We also have notes that are statewide. For example, you can see on that listing, asbestos workers, truck drivers, painters, and electric linemen are all statewide notes. It does not diverge based off of the county. It's notes for all 67 counties in PA. Electric linemen. So it seems to be that a lot of the work that will be taking place in these projects will fall under this category. The definition on our website, as shown to you on this slide, an electric lineman note basically states the assembling, installation, erection, operation, maintenance, repair, control, inspections of all apparatus devices, wire, cables, supports, conductors, ducts, raceways, conduits, including temporary, permanent, maintaining or restoring electrical service when part of outdoor lighting and wiring, when fed from the street and controlled from the street. We also go into some more detail on installation and maintenance of roadway lighting and traffic signals, any kind of work involving setting transformers and connecting windmills, solar installations. So the definition for electric lineman is broad. It includes the cables and supports that would be done in a lot of the work that will be taking place with this grant-funded project, these grant-funded projects. Truck drivers. I mentioned before that truck drivers may or may not need to be covered depending, right? We may have some material delivery. Some of that won't be covered. We may have some folks who are on a job site who are traveling to and from a location that is not a dedicated site to that project. That may not be covered. What my advice would be about truck drivers is, again, when we go back to our notes, we have truck driver rate or truck driver notes on here. But if you have a question about whether a truck driver is even covered, let us know that question and we can assist with those things. And let me also stress with this notes page, what you're looking at here. Just because we mentioned the electric lineman definition, there may be very valid labor work taking place, some very valid operator work taking place. These notes are extremely important for you to read through if you have a project in each one of these counties, because some of these notes will allow work to be paid at a different classification. The electric lineman note is set out so you know the ground rules. What's a lineman do? How do we designate certain work? And we have it on here. So all of these notes are integral for you to actually read through to make sure that you get a good handle on what should be paid to the workers on your prevailing wage projects. Project wage rates. So how do we even start, right? How do you even get rates and who gets them? Well, it's very simple. The application for wage rates appears on our website. It's real simple with about 5 questions. You provide as much information about the project, the location, the work that's being performed, and we would in our office review that. We will determine if that project meets the definition of a building job, a highway job, combination, as I mentioned before, and then we would get the rates back to you. You could also call our toll-free number, right? 932-0665. When you call us, we will give you instructions. There might be some folks out there that don't want to do this online. We get about maybe 100 a year on paper. That's fine as well. We can log those in as well. Not a problem. Interested parties have 10 days from the time when the project is advertised to challenge the prevailing wage rates. There's an official process and it's defined in the act itself. Again, we're blessed by the idea the law gives us the guidance on how things must be challenged. The challenging party, though, has the burden to prove what the prevailing wage rate should be in that locality. If there's a challenge to a project or a wage rate, it's on that person's burden to ensure that we get from that person what they feel the rate should be and why we were wrong in the rate we have on there. Those challenges have an official process. They're heard by the Prevailing Wage Appeals Board. This is what your rates will look like. Now, I'm not sure if you can see it, but I just picked a random job. This one in Franklin County, and it's a broadband project. So you can see in theory what the rate determination would appear as when you get it back. Now whoever requests these rates will get an email that will take you directly to our website where you can review these, download these. By the way, these rates not only must be downloaded by the person that's getting the grant or putting this out for bid, but the rates should be on the project itself. Workers have the right to know what the rates of pay are that they are receiving. So these wage rates should be posted somewhere on the prevailing wage site, perhaps the job trailer, wherever workers commonly, might get together and have break times, etc. We looked, by the way, when you get your rates back, we have two different sections, right? We have that building section, which I'm showing you on this page. Now, the building section will not necessarily be relevant to you unless there's any lines being established or placed into a building itself or any building work happening. What will be relevant will be the highway work, I would imagine, for the vast majority of the jobs that we're talking about today. So you're noticing, I'm sure, if you've never seen these before, or if you're kind of new to this, you're probably thinking, well, I see a whole bunch of rates that have a whole bunch of lines. Like I see a laborer 2 times on here. I see a carpenter welder twice. I see 2 different cement finishers. Let's look into some details. You do see a couple rates. So for example, I pinpoint to you on that project we mentioned in Franklin County, these are the electric lineman rates for this particular project. We have 2 different categories on your screen on this chart. The very, very first column, electric lineman, that's the name of the trade. And then the next line over is what the rate of pay should be for that person. The line over after that is the fringe benefit allowance that you would be able to claim as a fringe benefit. And then finally, that last column with dollars in there is the total package of the wage rate. The dates correspond to when the wage rates escalate or increase. So it's important to note that line, as you can see with my handy dandy arrow, points to you when the escalator occurs. If you have a project that begins, we pass this date now, but if you had a project that began on May 1st, the total rate that we would say you should pay to an electric lineman, total package would be $81.02. If that project continues after June 3rd, 2024, we now establish that that rate must increase to $83.41 total package. That's based off of this number here, which is the fringe benefit. So we have 2 different buckets of pay. Going back to this again, we have the wage rate and we have the fringe allowance. So looking at that line for the May 29th rate, we mentioned before the total package is $81.02. That means in essence, the contractor is responsible for paying their workers, who are an electric lineman in this case, $81.02 in some way. The rate being $51.40 and the allowable fringe credit that they can claim up to is $29.62. What are fringe credits? Let's talk about that. So for those who've done prevailing wage before, you may know. For those new to this, it's very important to know what a fringe benefit really is. A fringe benefit is a contribution that you as an employer makes to an employee benefit program. Sick pay, disability, death, medical, hospital, vacation, retirement, and pension. All of these could be considered for a fringe benefit credit. Those benefits that you're claiming must be for the benefit of the employee, not the employer. If you don't claim fringe benefits, you must still pay the remainder of that wage rate. Let me go back and show you again real quick. Let's say you hire me today and you have no benefits for me. I don't have vacation. I don't have sick pay. I don't have disability, nothing. In my paycheck per hour, if I'm an electric lineman, I must get $81.02 per hour. If I have benefits, however, that you pay in for me, let's say I co-pay medical, but you pay in medical as well for me. You can claim what you pay into me on an annualized basis to come up with an actual wage rate. And I'll show you how on this page. This is an example of how to figure out a fringe benefit credit. Now you can claim the actual dollars, is perfectly fine, but if you wanted to, we allow for an actual annualization method, which involves 1,920 hours as your divider. So in essence, if you paid in $10,000 for me for the year for healthcare, you take your 10,000, divide it by 1920, and it equals an hourly rate. It's when you don't provide me any benefits at all that you must pay for that fringe benefit in the form of a cash payment. So if you have any questions for us, and I'm sure you will, a lot of employers who do this a lot still have questions for us on fringe benefit calculations and what can be included and what cannot be included. Please contact us. We would rather have you err on the side of caution and ask us before doing something to ensure that you're not improperly taking a credit for something that you should not take a credit for, and thereby underpaying a worker on a prevailing wage job. Here again, this chart will be, I think, very important for you to maybe just print out and keep handy. It's a quick calculator as far as how you can claim that fringe benefit credit and how you add up those dollars. So now you're in the midst of prevailing wage. What do you do now? Well, the law says you have to do a certified payroll. Again, we're not making this up. It comes from the law itself. What is a certified payroll form? So the certified payroll essentially tells you as a contractor or subcontractor that you must on a weekly basis certify the rates that you are paying to your workers and show what those rates are, and along with it, show what the fringe benefits are that you're claiming. They should be filed weekly with the awarding agency, in this case, the grant recipient. It's my understanding that grant recipients out there will be eventually getting these back to DCED, and if I'm wrong, someone could correct me, but I believe that is what I was told the process will be. All contractors and subcontractors must file certified payrolls. Everyone who works on a prevailing wage job needs to show up on there. Owners who are doing work on a prevailing wage project and they're self-employed, believe this or not, must put themselves on a certified payroll form and pay themselves the appropriate rate and list that out as well. This is what a certified payroll form looks like. For those who maybe never did one before, it might look scary, it might look frightening, but believe me, it's actually not. It's very simple. As you can see, we're naming the contractor on top, the subcontractor who's performing the work next. The payroll information that comes from your own information, the week ending date that comes from your information, the project and location that comes from what we give you. As mentioned before, when we give a rate determination out, it will be on our website, but it also gets a project serial number. And that serial number will be the easy way for you or for anyone else to look up the wage rates anytime on our website. That serial number will go onto the certified payroll form. You will list out the employee names. You will list out the work classification that they are performing. Each column on that little chart in the middle is the day of the week. And then finally, we talk about the base rate, fringe benefits, and those deductions they're taking along with the check number that you paid them that work from. So don't be too alarmed by this document. It's real simple. It's just detailing out what you're doing on a prevailing wage job in order for anyone reviewing these projects to ensure that rates are being paid appropriately and that all workers who are on a project are being listed. Overtime on prevailing wage jobs. So mentioned before under the minimum wage section, we don't talk about overtime and prevailing wage at all. The law is silent about overtime. The prevailing wage law simply says you must get the prevailing wage rate. The minimum wage law talks about overtime. So remember we mentioned before, we have your base rate and your fringe benefit credit that you can take to total what your total package is that you must pay to a worker. So going back to that example of the lineman I mentioned, the rate was $51 per hour. The fringe benefit was $29. You're on the hook to pay 80 something an hour, right? You cut down that by having fringe benefits. But let's say you have no fringe benefits. And let's say now that that worker's getting in their paycheck $80 per hour, but they also work 50 hours this week, time and a half of 80 now. That's what this would mean, right? So pay very close attention to that matter. Prevailing wage is one thing, but in the other category of overtime, it's based off of the hourly rate someone is making. So if you're not taking a fringe credit, it increases your overtime liability that you must actually pay to a worker. I will mention Bureau investigations. So I just want you all to know, we get complaints a lot about projects from workers who believe that they have been underpaid on a job. We investigate those projects, but we also initiate our own site visits. We randomly go to sites throughout the state. We look to projects that are taking place in areas where we might already be looking somewhere different, and we stop by these job sites. We try to police these to the best of our ability. We're limited in staff, of course, but we also try to get to as many job sites on an annual basis that we can. It's a lot of work out there. There's a lot of prevailing wage projects, and this grant will lead to that. But it is our mission to ensure that we are enforcing prevailing wage. And not only that, but also checking for child labor issues, minimum wage issues, and Act 72 issues, which was the misclassification of workers on construction sites. When an investigation would occur, we work with contractors to obtain information. If there is an underpayment in some form, we tell contractors to pay those workers back. If there's an intentional underpayment, someone who purposely set out to avoid paying prevailing wage, that could be a whole different category of something more purposeful. Those are rare, but when they happen, we treat them very seriously. Resolution. So we, again, our investigations, minimum wage or prevailing wage may actually open up a company-wide audit for us to look at more than just one project, or if it's overtime, to possibly look to other workers not being paid time and a half. So it's important to know what these laws are and to ensure compliance, because you all want this program to work well. We do too. And it's important for us to try to educate as much as we can to avoid these really unnecessary actions. Posters and information. All the information we're talking about today is for free. If you get any phone calls from anyone saying you must buy posters, I guess you could if you want to, but you don't have to. They're all for free on our website. We provide for you color copies if needed. We can mail them out, whatever your request of us may be. But all of our posters are downloadable, and you should post them on your job site. I mentioned before about the rates. You should put your rates somewhere, job trailer, whatnot. We would ask you to as well hang these posters up so people know their other rights concerning child labor, for instance, or unemployment compensation or workers' compensation. That's it. We left in some window of time here for questions and answers. I don't know if anyone has any questions and answers because I wasn't looking at the chat.
Hey, Brian, that was a wonderful presentation. I haven't seen any questions in the chat. If anyone has a question, please feel free to put it in chat so that we can ask Brian.
And Mel, I believe that this PowerPoint will be shared. Do you have a plan on how you're going to do that with the entire group? Because again, my contact information and our resource account email is in there.
Sure, of course. So I believe, Kaylee, if you want to answer that, because I know we're recording this session also to put online.
We're happy to take that. Thanks, Mel. I know we'll be able to gather via the WebEx coordinator all those that participated today, and there should be contact information in there as well. So we can utilize that to push it out. Additionally, many of you are familiar with me, but I will drop my contact information in the chat right now. You are welcome to reach out to me directly if you do not receive it within the coming days to request it or to be added to our distribution list if you are not already on it.
And Brian, if you'd like, I can actually drop is it just your CWAPA email? I can drop it into chat if you like.
You can
Or
do that.
the
I mean, we have a resource account email, but it's perfectly fine. You can put mine in there as well.
I will do that. And I haven't seen any additional questions come in. I know prevailing wage can be a little intimidating. I've been on that side as well.
My hope today is that we sort of lessen that intimidation. I don't want to simplify it too much because obviously it gets technical and we didn't go into the real technicalities today. I wanted to keep it very broad. But in theory, you're being paid for the classification of work. It's a different game, right? We mentioned before, you're in a different sandbox. You play by different rules when it's prevailing wage. We have the non-prevailing wage work, which is very separate. When you do prevailing wage and accept taxpayer-funded grant money in some form, a different set of requirements gets put onto jobs of that nature. So hopefully today we dispelled some fears and maybe got knowledge out there to people who really need it. But we're more than willing to do these anytime and provide any other information as people have questions.
Wonderful. Well, I don't see any questions coming in, and we've chatted a little bit to give people the opportunity. Brandon, did you have anything you would like to close with?
I just want to thank Brian and the folks at Labor and Industry for helping us out with the information today. Brian, great job. Looking forward to pushing the slides out for folks. If you do have questions that come up as you're developing your projects and working on those applications, don't hesitate to reach out to Brian at his email or at the RA account. And again, I'll reiterate, the authority staff are here for other program-related questions as well. Don't hesitate to reach out via our resource account so we can get some responses back to you on that. So I want to thank everyone for taking some time to jump on today and hope you enjoy the rest of the day.
If I could real quick, I apologize. I received a direct question myself from Kevin Sunday. The question is average turnaround time to determine wage classifications.
Great question. So I'll brag about us because I'm actually proud about this one. We do about 200 of these a week and we get them out within 24 to 48 hours. Now, if you put one in on a Friday at noon, you may not get it till Monday, but typically we're getting the turnaround time down to even less than 48 hours, sometimes the same day. So I know we may have an increase of these as projects roll in here, but I don't envision you waiting more than 2 days. And if you do wait more than 2 days, call us because we may not have received it or there may have been a technical error because otherwise you'd be getting it back pretty quickly. And I don't hear anyone talking. Is someone frozen? Am I frozen?
Nope, you're good. I don't
Okay.
think there are any, unless somebody else had a direct question. Well, thank you so much for your time, Brian, and everyone on the call. We appreciate you.
All right. Thank you, everyone.
Yep.
Have a nice day.
Bye.